Good morning, everyone. I am Milena Carranza. I am a PhD student of the program of Rule of Law and Global Governance of the University of Salamanca, and today I will be talking about the right to health effectiveness and its relationship with the administrative function of regulation. So first, I want to begin talking about the essentials of the concept of effectiveness of rights. So the first factor of effectiveness is organizations, the existence of organizations that rule and enforce rights. Ruling is the administrative function of regulation as such, which is an administrative function that develops all the legal framework of the right to health, and the organization that enforces the right is effectively the one that binds the state and all the institutions, all the organizations that protect and that also provide the service of health to make a human right a legal right, to make a human right enforceable. The second factor is the absence of unreasonable limitations regarding the exercise of the right to health. So non-regressiveness is the first one, because when we say non-regressiveness, we are talking about the substantive and procedural force of the right that prevails always over any restriction of the state, and the state is obliged to protect the right to health according to the substantive and procedural rules, according to the nature of the right, and according to the object also of the right, which is protecting health in a very high standard, according to the European standards, for example, here in Spain, that we have a universal system, a universal health system, which is a very high standard. So we have substantive and procedural rules that must be protected. The third factor is the procedures. If we have organizations, we naturally must have procedures to protect, to make the right enforceable before not only the organizations that provide health, but also the organizations that enforce. It is the judiciary, but also in more particularly the administrative authorities that exert regulation. So basically, I am talking a goal-based approach, which depends on a mandate relationship between the principal, which is the constituencies, the legislators, the states, the international organizations, and all the organizations engaged in the recognition of the right to health, according to several covenants, international agreements, constitution as such, the law, because we have here the legislators, and this legal framework operates as the goals that are fixed in this mandate relationship, that is the way that we're going to assess effectiveness of the right to health through a mandate relationship between the principal, that is all these institutions that fix the goals. So the mandate as such are the goals fixed in the law, in the constitution, and all the supranational laws according to the legislation and according to the country. And the agent in this mandate relationship is the regulator. The regulator must maybe the Ministry of Health, or in some cases, a semi-independent or an independent administration. So we have here a mandate relationship, and we have to focus on the way this relationship is developing. So which are the goals that are fixed by these constitutions, by these legislators, or by these principles that we are going to say about principles? Which are the goals or the telos, which is aim or goal that the agents must follow according to the principal's preferences. These goals fixed in the Constitution. But the principal's preferences must be developed by the regulator at the administrative level. So the administrative function of regulation is all those procedures developed according to time and budget constraints and according to some determinants of health. This is very important. This is very important in a mandate relationship because it is not only about the goals fixed in the Constitution and in the law, but also these goals are according to time frame, budget constraints, and determinants of health. Legal constraints are also important in order to establish which is the telos, which is the goal that the regulator must have in order to regulate the right to health. The first one, the first legal constraint, is the nature of the right. If the right is considered a fundamental right in its full scope and extension, which is very broad, which is very wide in the protection, or if the right to health is just a social and economic right. Maybe some scholars may say or may think that here in Europe it is not necessary to do that division, but maybe in some other countries like middle income countries, or for example in Latin America, this is a very important debate. But we are not going to talk about this very broad and very deep issue because the nature of the right, let's say only that the nature of the right is very important and we're going to discuss it in the next slide. The object of the right is also very important because if we say that the right is over technical issues and technical matters, which is health, which is health indicators, health standards, we must say that the object of the right is technical. So technical standards and technical criteria must govern the way the regulator acts. The regulator develops the right to health according to technical issues, according to technical criteria. So the object of the right also determines these telos, these goals. Lack of clearness or ambiguity of the legal precepts may be also a constraint, a legal constraint, because the regulator must have the capacity or the ability to fill all these gaps of the legal precepts. Maybe the constituencies, the legislators, the states, or the covenants in the international level do not have very clear or exhaustive precepts. So the regulator must rule these goals in order to have a clear concept and a clear goal to make this right effective. And the last constraint is the legal design as such, the legal design of the regulatory organization. So this is a paradigm. This is also a paradox. This is a paradox because the legal design of the regulator is also a limitation of itself. So we have here a problem if you see. Their attributes and the accountability regime is also very important. It will determine the effectiveness of regulation. So this is a paradox because sometimes the regulator decides its own design. So this is very, very interesting. The ministry, for example, decides its own function in some regulations. For example, the presidential or the Latin American states. So we have said that the nature of the right to health is a material limit for regulation. This is a constraint or a limit for regulation because the right depends on several factors. The prerequisites for health, like peace, shelter, food, and income, and the determinants of health, like employment, social class gradient, transport, or also the genetic endowment of the person, will determine and will remark in the path of health, but also the technical nature of the object, as we have said. It determines the decisions, the features of the institution responsible for them. The organization in form and in substance will be determined according to the technical nature of the object. For example, the Ministry of Health must have several technical committees in order to have very clear precepts, very clear regulations in order to regulate the issue. The third one, the nature of the right is a material limit because regulation as such is associated with compliance, with the concept of compliance, which has the responsibility of allocate efficiently the resources which are very scarce according to very important, very focused targets. So this is a very technical task. And rational deliberation is also a burden of technical decisions. The rational deliberative procedure is also an obligation of the regulator. The inherent fundamentality of the right to health is also a material limit of regulation because it objectifies regulation and separates it from the political struggles. And we have here an example of these political struggles because there are time frame constraints. For example, the electoral cycle of a government determines when the decisions are going to be taken. For example, in the year one, if we have a government that is a 4-year period, a government in a 4-year period, it will probably take these difficult reforms or non-popular decisions in the first 2 years. In the third year, maybe it is going to have the possibility to take technical decisions, but in the last year, maybe it is not going to have these technical decisions to make. So popular decisions are going to be taken in order to be re-elected. So this electoral cycle is a commitment problem for the political organizations when political organizations are in charge of technical regulation. This regulation needs very strict regulation according to technical criteria, but regulation turns uncertain and non-technical when it is taken by political organizations that depend on the electoral cycle. So, in conclusion, the technical regulation arises in this regulatory state context because we are seeing that it is necessary to have more technical organization, maybe a non-majoritarian organization, maybe the ministry, we have to make it more technical in order to reduce uncertainty because it is always going to depend on the political cycle. The institutions also need to be enforced through organizations which have to have the same protective objectives, the same goals, more politically neutral organizations as we have said, for example, through delegation to regulatory commissions, and of course, independence and accountability. Independence as for example, organic, financial, managerial independence of the regulator will be the guarantees of a better regulation to protect the rights. And of course, accountability. These mechanisms of accountability are the necessary counterpart of independence. Thank you so much for your attention and have a good day.